I'm not sure.
I know we have a required meeting that day. What time is that?
2 o'clock.
For what? Required meeting for what?
Picking our schedule.
Okay, so 12, perfect.
Yeah.
What?
Yes.
Hold on, one at a time. What time is your Langdell?
12.
Is it for this class? Your Langdell for this class is for Friday at 12. Do you have anything Friday at 12? Your Langdell for contracts is Friday at 12.
Yes.
Oh, okay. What do you have at 2?
We have to go to a mandatory meeting so we can talk to.
How long is it?
2 hours.
Unless you got a way to get us all out of that, that would be good.
So here's the interesting thing, my friends. The longer I postpone this, the more you panic and worry, oh my God, what to do my exam? So you're all going to be here at 4 o'clock on Friday? We'll do it at 4. 4 o'clock at Friday. Are there any conflicts? I have a faculty meeting at 10. Trust me, actually, I would do it actually at 9, but I can't have a meeting at 10. So we'll do it at 4 o'clock on Friday. Does that work for everyone? No one has any conflicts. I realize that's probably far later than anyone ever wants to be at law school. But I'll try and keep it breezy and light, so it won't be too painful. Anyway, the purpose of this is for your benefit. Anyway, so I'm just about done with grading them. What I'll probably do is have you pick them up from Cindy on Friday, and that way we can just go that day. So that way you'll have the papers in your hands. I'm just about done grading them. Just a tip, if you do this again, I gave each of you, this is actually part of the delay in giving you all your grades back. There was a special exam number you're supposed to use for the midterm. At least one of you used an exam number from last semester. That makes it very, very, very difficult for me to figure out who you are. So the registrar is currently trying to figure out, because the number you put in the book is not a number I have a record of. So just for the future reference, make sure you use the correct number on your midterms for the future. You know, it's like in the SAT, you get like 500, points for writing your name. If you don't write your name, I don't know who you are. So you put a wrong number. You actually weren't that bad. In my common law class, 3 or 4 students wrote an exam number that wasn't their exam number for the semester, and I have no idea who they are. One student actually wrote their South Texas ID number, which I'm not even supposed to have access to. So I had to give those, stack of books to the registrar and say, okay, you got to figure this out because I can't do this. So, but you guys are good. Only a couple of you did that. So I think for the most part you'll be okay. But so far, actually, don't worry. I'm actually pleasantly surprised. Compared to my common law kids, you did better. It's not good for them, but it's good for you. But for the most part, I'm actually pleased with your exams. I mean, you'll have them back by Friday, by the end of the week. But for the most part, I'm relatively pleased. All right. Any questions beyond? Let me make a note of that. Okay, Friday at 4 o'clock, and we'll probably in this room. Okay. It'll be a very good Friday for all of you, I suppose. You'll all be here at least. That's a good point. Okay. So questions, things in your mind. Anyone have any interesting break stories?
So Friday you're going to give us back our test and the review will come out?
Yeah, what I'll have Cindy do is they'll be available in her office at any point during the day. And if you just go to her office and pick them up, they'll be there. I mean, you can pick them up right at 4 if you want. You can pick them up at like 10 or whenever you get to school. But I think she's usually gets there around 9. So whenever she gets there, she'll be able to hand them out for you. And just make sure you have your number that you can pick it up. Or in the case of people who didn't put the right number, whatever number you have. Hopefully you can figure it out. Yeah, but you guys do good. I'm actually proud. I don't always say that, but you actually did well. You did what I wanted you to do, so I'm not worried. Okay. Any other questions? All right, let's start. So the wonderful news for all of you is that we are done with future interest, right? Yes, we can clap, right? Please clap, please clap. So, oh, right. So the good news is, right, we're done with future interests, and we're moving on to the next portion of the semester, this class and the following class, focusing on what's called co-ownership. Everything that we've studied so far has focused on the two questions, right? Who owns it and when do they own it? And it was always Josh has a life estate, Bill has a remainder, you know, Sam has reversion. It was always at different points in time who would own the same piece of property, right? At any one given point in time, though, there's only one person on Blackacre. That's always what defined our topic so far. At any one given point in time, only one person owned Blackacre. I'm actually going to sit down. I'm still not going quite well enough to teach, but I'll manage. Our next topic, and what we're discussing there we go. Our next topic, and what we'll be discussing going forward, is what's called co-ownership. That is when two people have a stake in the land at the same time. This topic sounds deceptively simple, but for reasons I don't fully understand, every semester it gives students difficulties. And the reason why I think it gives students difficulties is because at some point in your lives, you were all roommates. And you were all taught as roommates, say if you had a 2-bedroom apartment, right? This is my bedroom, you don't go inside. That's your bedroom, I don't go in your room. We split the rent and that's it. So everyone always thinks of roommates as a model for co-tenancy, where I have my stuff, this is my side of the fridge, right? This is my food, that's your side of the fridge, that's your, right? Everyone knows what I'm talking about? This is not how co-tenancy works. The idea of co-tenancy is not this is my room, this is your room. Each person owns the entire piece of land. Each person has access to the entire piece of land. Okay? You don't exclude someone from part of the property. Instinctively, students want to think as a co-tenancy as, you know, I own 50% and my roommate owns 50%, right? Even the way you pay rent, you split the rent in half. Co-tenancy does not work that way. Both of them own a 100% interest in the land. They each have their own claim to it, but their claim is to 100% of the property. That makes sense? So the sooner you're able to remove from your mind this image of you and your roommate splitting everything 50-50, this is my side of the room, this is your side of the room, the sooner you can remove that from your mind, the sooner you'll be able to understand this topic better. Because otherwise it gets very tricky. And I promise you at least one person today will try and view it that way, and I'll remind them gently, but I'm warning you in advance. All right, so any questions on that so far? All right, so let's start, and to bring my computer down so I can actually reach it. There we go. So we start and we talk about the various types of co-tenancies. And the first one I want to talk about is what's called a tenancy in common. Okay? The tenancy in common. Super extra credit. Does anyone remember where we were last semester? Before the break, it was a while ago. Does anyone? Wow, you remember. Did you write that down or you just remembered? That's really impressive of our. I make no efforts to remember these things, and I'm always impressed when students do. So, ma'am, can you please tell me if I say, right, to A and B as tenants in common? That's it. You know what? I mean, I've given you this, you know, from to A and B for life, to A and B, you know, for in their heirs. We've done that before, but now I'm giving you this. You can peek over my little lectern, right? To A and B as tenants in common. What does that suggest? What does that mean when I write that out?
They both have the same but undivided interest.
Okay. I like the way she phrased that. I'm going to tweak it a little bit, right? It means they have what's called a separate but undivided interest. You said same, I say separate. It's actually more closer than you think. A separate but an undivided interest. Okay. What that means is that as tenants in common, both A and B have their own independent claim to Blackacre. But the interest is undivided. That is, they each have a right to enter all of Blackacre. One cannot exclude the other. In fact, we'll do some cases, I think, next class, where one tenant tries to lock out another tenant, and that's a problem. What does it mean for it to be separate? Okay. Sean, were you next, or? Oh, that he remembers. Did I call you guys? All right, Serenity, I'll jump over there. Serenity, what does it mean for a person to have a separate interest? What can they do with that interest in Blackacre? What can A or B do independently of the other? Exactly. When you say you have a separate interest, that means you can sell it. You can sell it, okay? You can convey the separate interest. Now, what happens if, Serenity, let me ask you this question. We have a situation where A and B are tenants, then you sell me your share. What's the new arrangement like then?
So they were tenants.
They were tenants in. So let's just make it easy, right? You and Jessica were tenants in common, right? You sell me your share. Who are tenants in common now?
The person who I sold to, Jessica.
Exactly, right? Jessica and Serenity in common. Serenity sells me her share. Now Jessica and I are tenants in common, whether she likes it or not, right? This is how it works. You can convey your interest separately. Okay. What happens, Jessica, if, say, God forbid, something happens to you and you die, right? What happens to your share as tenant in common? Where does it go? To your heirs, right? Another characteristic of a tenant in common is that when a person dies, it goes to the heirs. It could be with a person with a will. If Jessica dies without a will, it goes through the intestate policy of the state, but it goes to the person's heirs. Okay? Everyone get that? So the key factors of the tenant in common is that you have the separate but undivided interest. You can sell your interest, independently. And when you die, it goes to your heirs. And I'm going to repeat this again. It's not a 50-50 ownership, right? It's not, I own this half of Blackacre and he owns that half of Blackacre. I want you to resist thinking about like that, even though I know some of you will, but try just not to, okay? Okay. Now, you can imagine, though, that this may get tricky, right? So say it starts off really nice and neat. Jessica and Serenity are tenants in common, right? And then Jessica leaves her share to her heirs. Let's say she has 15 heirs. Okay, so now Serenity is now tenants in common with 15 people. That can get messy, can it? Because you have all these people running around the property, you know who they are. So the common law didn't particularly like this idea of tenants in common because it allowed too many people to chop up the same piece of property. So an alternate estate, and again, these are all estates. I mean, I'm not asking to add them to your list, but you may as well. An alternate estate is what's called the joint tenants or joint tenancy. Okay. Jonathan, what is the key difference between the tenants in common and a joint tenancy?
Isn't it the 4 unities?
Well, there's a unities too, but what's the key difference in how they actually operate?
when it comes to the right of survivorship?
The right of survivorship, right? So as I said a minute ago, if Jessica dies and she leaves behind 15 heirs, now Serenity's stuck with these 15 people running around. That is very messy. So the joint tenancy has something key called the right of survivorship. The right of survivorship means that the person who survives now gets the property in fee simple. Okay, so to use the example, you have Serenity and Jessica on Blackacre as joint tenants. Jessica dies. Serenity now owns Blackacre in fee simple. That is very neat. You don't have to worry about her 15 heirs running around trying to split up the property. Whoever the other joint tenant was, who wins the ultimate game of life, survival, they are now the sole owner. It's really, I wasn't being entirely facetious, but this is the ultimate game of life. Whoever lives the longest gets the property. I don't know, if there are any Simpsons fans, there's an episode called The Flying Hellfish. You know the episode I'm talking about? There was an episode where Grandpa Simpson was back in the day fighting the Nazis in Germany, and they discovered this cache of stolen artwork. And all the soldiers made a promise saying whoever lives the longest will keep this artwork. And then it comes down that the final two that are still alive are Mr. Burns and Grandpa Simpson. And then, of course, Mr. Burns is trying to kill Grandpa to get the artwork. And in the end, there's some sort of, German brat shows up and takes all the art. But the idea is you have these agreements where whoever lives the longest gets the idea. And this is the idea of the joint tenants. And this made even more sense at the common law because there was no wills. People didn't have wills. So usually the only piece of value that any human being had was 10. So you can imagine, two people living in a piece of property, one dies, well, then it goes to the other one. Okay? So it's actually the joint tenant survives and continues free without fee simple. Okay? This is also very helpful because there's something called probate, which I don't think I've mentioned much. But probate is the process where after someone dies, you go through their will and you try and figure out what their intent was. That's a very expensive and time-consuming process. The joint tenancy defeats the need for a probate because the second the husband dies, the wife, for example, will get it. I'll get to the tenancy in entirety in a minute, but the general idea is it happens automatically. Not all states have a tenancy by the entirety, so in some cases, married couples just have the joint tenancy. All right, so everyone get the idea of the right of survivorship. That's the biggest key difference between a tenancy in common and a joint tenancy. Try not to get them confused. You have tenancy in common and joint tenancy. You have common and joint tenants. They're framed differently, but they're the same thing. If you see the word joint in there, more likely than not, it's a joint tenancy. And that way you can help keep track of what's what. Okay, so everyone with me as far as the survivorship. Okay. Now, creating a tenancy in common is really easy. I gave you this example, right? To A and B as tenants. There we go, much better. To create a tenants in common is very easy. If you just say to A and B as tenants in common, that's it. Creating a joint tenancy is far more difficult. And I think Jonathan mentioned this a moment ago. You need to have what are called the 4 unities. And before I tell you what they are, let me tell you why. The entire idea of a joint tenant is that these people are going into the transaction together and they're going to leave the transaction together. Because one of them died, right? They're in this for the long haul. And the law developed to ensure and to make damn sure that these two people were actually interested in having this right of survivorship, right? Landon, why is this right of survivorship so significant, right? Why is it that we want to be sure that they intended this to be a joint tenancy? Why do you want to eliminate any doubt?
Because your interest doesn't go to your heirs, it goes back to.
Yeah. I mean, if you think about this, guys, it's a really big deal. You're cutting your heirs anything. That once you get into this joint tenancy, you are guaranteeing your heirs 0. That the property goes upon your death to this other guy. So the common law developed very stringent tests. Excuse me. Very stringent tests to make sure that both parties knew what they're getting into. So when you look at these 4 unities, don't just think of like these, these nice 4 things you're having to meet. Think of the practical purpose. The purpose was, we want to make sure that both of these guys have their eyes open and they know what they're doing. Because once they enter into this arrangement, their heirs are out of luck. Okay. So you want to walk me through, Graham, these 4 unities, and what are these things that we have to show?
First is time,
Thank you. Yes, time. What's the second one?
title, interest, and then possession.
Okay. Time, title, and if you want an acronym, TTIP. It's how generations of law students have remembered this since time immemorial, and you will be the next crop to do so. So, Graham, let's start off. What does the time unity mean?
Just refers to the interest of each joint tenant must be acquired or it needs to vest
Okay.
at the same time.
In your own words now.
Just, I guess, when they enter into the agreement, both of them, they need to do it kind of at a time. It doesn't need to be subsequent.
Right. So let's just use you and Landon as an example, right? So Landon signs his paper on Monday and then you sign it on Tuesday. Is that at the same time? Okay. Graham, why do you think it's important that you both sign the document at the same time?
All sorts of things, I guess, could go wrong. I mean, if you give-
For example?
Yeah, if one person who signs it, Landon signs it on Monday, and then all these things can happen in between then.
Yeah.
Sign it on Friday.
Exactly right. Imagine Landon signs it on Monday, and then on Monday afternoon, Graham's like, "Oh, great! I'm gonna go do all these crazy things. I'm gonna become a gambler, go into debt." Right? You may not want to be his partner anymore. It's like, so screw this. I'm not signing this anymore. So you have to sign them at the same moment in time, right? Cameron, you want to tell me about the title? What's this unity about?
They actually have ownership of getting what they think they're getting.
No. What does it mean to have the same title?
Their interest is
Where are you getting this from? Is it in your notes? There are only 10 pages of reading. It's very long. I'll come back to you. Do you have it, Natalie?
Would it have to do with their, like each of their ownerships having
The same instrument. That's the key point. In property, when we say the same instrument, what we're actually referring to is a literal piece of paper, okay? An instrument is a document that has a legal significance, okay? An instrument is some sort of document that has legal significance. You'll talk much more about this in property 2, of what these actual documents are, but there's something called a title. And title, to summarize it very briefly, is the land to another person. And it can take various different forms. But you have to have it on the same instrument, right? Now, Cameron, why do you think it's important to have both joint tenants agree to the same instrument?
1 doesn't have more weight on it.
I'm sorry?
I'm really not sure.
Did you do the reading today?
I don't remember if I read too long ago. I think it was. So like, one's on paper, one's not oral. So there's equal proof for both parties.
Okay. Elizabeth, what do you think? Why do you think it's important to have the same instruments, same title?
The 4 instruments, it's so they're going into it with their eyes open, and it's very intentional, and if it transfers by law or by some other means.
Yeah. Yeah. So imagine, right? Let's take an easy example. Let's say that there are 2 separate instruments. I mean, one signs contract A and one signs contract B. This is before computers. There can be errors made, right? There can be transcriptions errors. Maybe this contract has these terms and that contract has a term missing. The requirement that they sign the actual literal, same piece of paper, like Elizabeth said, their eyes are open. They know exactly what's in the paper, and there's no doubt they know what they're getting themselves into. There's not a question. There's not a possible, argument about what the actual terms are. Yes.
I was kind of curious about a handwritten modification. Like A signs the instrument, but wants to like modify something or a clause. You have to like tell B that he made that modification.
Well, I mean,
But it's the same paper.
right. So, I mean, this is something which you may have done. Usually, if there are any modifications made to the contract, both parties have to countersign. In other words, both parties have to sign off, initial next to wherever the modification was made. So that way it's clear that party A and party B are aware of what the exact terms are. Yeah, I mean, that's more of a contract principle than anything else, but it really matters in for purposes of the joint tenancy. So everyone get the time, everyone get the title. All right, Kenneth, tell me about the interest. What does it mean? What does this unity provide? Okay, so then in your own words, please. Very good, yes. This is what I was trying to say before. They must have an equal undivided share. They each must have effectively access to the entire property. It isn't the case where John owns 1/3 and Bill owns 2/3. Okay, the instrument that they sign at the same time must make clear that they each own everything. This is why the time, title, and instrument are somewhat redundant, because it's really the same document that they sign at the same time. They make clear they own everything. I mean, those 3 are almost like one block unto itself. Yes, sir. I'm sorry? Okay, so for example, if it says Josh and Bill own Blackacre as joint tenants for the next 10 years, right? Neither of us own it forever, but each of our interests are at the same period of time. But if it said Josh owns Blackacre as joint tenant for 5 years and Bill owns Blackacre for 10 years, right, as joint tenant, that wouldn't fly. You can actually give joint tenants for a person's life. So you can actually make a combination joint tenancy life estate if you want to really get complicated, and that's also duration. Yeah.
Going back to the instrument, it says the same instrument provide a joint adverse possession.
You'll do adverse possession next semester, so don't worry about it now. Adverse possession, briefly stated, is squatting. So if so if one person squats on a piece of land for 10 years, that person can actually acquire a claim to it. But what gets even more complicated is, what if one person squats for 5 years and then his friend, tag teams, slaps in, he squats for another 5 years. You can actually tack together those 5-year periods into 10 years. You'll do this next semester, but you can actually acquire property as joint tenants through squatting, if you can imagine that.
Yeah, So if you don't put like a duration on it, you just assume it is for life, or
Whoa. For whose life, though? With a joint tenancy, what's the longest it can last? Think about that for a second. When must a joint tenancy expire?
Oh, well, when the person dies.
Exactly. So it can't last forever. It has to last at the longest, right? Until person A dies. Then it goes to the right survivorship to person B. That makes sense?
Just want to ask why the example you gave where, let's say Josh has possession for 10 years and Bill has possession for 5. Why do they have to be equal? Why can't they, like, why is it that they can't be different for the joint tenancy?
Well, if I did it, I have it for 5 and he has it for 10, then it'll be a tenants in common. Because the unity is not present, right? We don't have the same interest. The unity is not present, therefore it becomes a tenants in common. The lesson that you have to think about is if at any point, if one of the 4 unities is not present, it becomes a tenants in common. There's no problem with me saying, you know, Josh is a tenant in common for 5 years and Bill for 10 years. That's actually okay because the durational requirement's not there for tenants in common. But it cannot be considered the joint tenancy and there's no survivorship, right? Questions? Again, so the time, the title, the interest, those are almost all going to be indicated in the same document, right? You're signing the same piece of paper at the same time, and each says you have an equal share in the property. Okay. Christine, do you want to tell me about possession, the final unity, please? Exactly right. The possession element is, again, somewhat redundant. If you're noticing, these are somewhat overlapping. But the possession element says that each of the joint tenants has complete access, complete possession of the entire property. You cannot lock your joint tenant out of your room. You cannot lock your joint tenant out of your favorite part of the property. We'll do a case, I think, in the next class where the husband tries to lock his wife out of part of the property. This doesn't work because indeed, once you lock out a joint tenant, you've now severed a unity. Okay? You've now severed a unity. And if you lock someone out without the permission and you sever the unity, congratulations, you now have a tenancy in common and you've lost your survivorship right. So I'll get you in a second. The entire reason why people play nice with the joint tenancy, why they put up with all this stuff about not, having to keep them full access and everything else, is that they're trying to hopefully live long enough to enjoy the right of survivorship, because that's a very big deal. But if they screw up and they lock out their joint tenant, or they convey their interest to someone else, they lose it.
Locking out someone is automatic.
It can be, yeah. We'll do a case like this next class, and you'll see how this works. But in many cases, once you lock it out and they go to court, they can say, look, they've severed unity, therefore survivorship rights gone. But more often than not, how this arises is I lock you out today, right? And then I die a couple years later, and then you try and give, and my heirs show up saying, oh, look, he locked him out. I'm the heir. He's like, no, there was no lockout. So often the dispute happens much later, right? Once the person's died, saying, well, was this actually a lockout? Was it not? Because the heir is always fighting with the life survivor. I saw a hand somewhere over there. Oh, very good. Yeah, more often than not, this arises after someone dies, and there's a fight between the heirs and the surviving joint tenant. And then indeed the question arises, was the unity severed?
Once they sever it, can they usually decide to make it a joint tenancy?
tenancy again, or is that automatic?
Yes, but how can they do that? How can they reestablish a joint tenancy?
Allowing speakers access?
No. What must they do?
Sign a new document?
What are the no, what are the requirements for joint tenancy? Think about it. What are the requirements?
Time, title,
You got to start from scratch. In other words, if say you and me, right, we're joint tenants, and you lock me out, that severs a joint tenancy. Even if you remove the padlock, that doesn't magically bring it back into form. We have to start from scratch. We have to have a new instrument, a new time to sign it, that says we have equal interest, and then full possession. You basically have to start from square one again.
I know our future case benefits on this a little bit, but it seems like joint tenancy is just a denied risk in that.
It is.
I mean, you're trusting the other person to kind of hold their end of the bargain. I mean, especially if you can just terminate it by transferring it to yourself, then you could be laying on your deathbed like the woman was later and say, "Oh, like tenancy's going on. Sorry, transfer to my heirs."
It's very risky. You're exactly right. There's a lot of trust in the other partner, and every partner has an incentive to try and screw you over. But the way it worked historically was that if party A did something bad, party A would also lose the right of survivorship, right? That was a really big deal. So the thinking was, at least at common law, was that this pot of gold at the end of the rainbow, this right of survivorship, right? That would be enough to keep people honest. But as you astutely note, that doesn't always work. This is why today the book talks about these presumptions. But today the presumption is that the courts prefer in common over the joint tenancy because the exact potential for abuse that you mentioned.
One, you just brought up something else that I was kind of confused about earlier. I remembered it saying, I think, if one party murders another, then basically that party that did the murder, the murderer's right is extinguished and the deceased person.
I mean, there's a general maxim in the law that you can't profit from your own crimes. Right. This actually comes up, I think, when Son of Sam tried to publish a book or something. You may have read about this in one of your classes. So if indeed one of the joint tenants kills the other one, I think the courts would find it in their equitable powers not to give him the right of survivorship. This is like the child who kills his parents then cries about being an orphan. I don't think that would work.
But I'm surprised that whenever you prevent someone from entering a certain part of the property, it doesn't have the same effect, basically.
Well, it severs a unity, and it makes into a tenancy in common. And there's nothing wrong with.
Extinguish the guy's right.
Well, I mean, that's extinguishing his right. That's not killing him, right? I mean, he's still alive. Yeah.
And so would, if your joint tenant wanted to invite a guest on the property and you locked that guest out, do you have the right to do that with that?
So actually, that's the case. That's the case you'll do for next class. It involves a boxing ring, where there's a joint tenancy, and the husband, without the wife's permission, decides to build a boxing ring on their property, and they're actually admitting spectators who are paying, and the wife gets nothing for it. So read that case and ask me that question on Thursday, okay?
I know the tenants in common have, I guess, that separate but undivided interest in the whole. And then when it started out with two, and then, like, let's say Jessica passes. I'm sorry.
Rest in peace.
Too soon.
She had the 15 children or whatever, or 15 heirs or whatever. Does that mean that Serenity's interest somehow is diminished? I mean, I know she
yes. So the short answer. So Sarah's question is this, right? If you're a tenant in common and your co-tenant dies, and 15 heirs have now, entered to that claim, Serenity is now tenants in common with 15 people, and each of them will then have access to the entire property.
And then,
so does that diminish her claim? You bet it does.
Okay, like if court were to, not that they normally do, but if they were to force them to sell the property, would Serenity only get like 1/16, or would you get?
So the issue of the sale is tricky. Courts don't always force what's called a partition or force sale. But were they to actually force a sale, then I think what would have to happen is that Serenity would basically get half of the value of the land, and then the other 16 kids would split the other half. I think that's how it would work. But courts don't like enforcing forced sales. Yes. I'm sorry, Jess. We're using it as a bad example. You were just in the wrong seat today.
I actually have a lot of property. Possession can be destroyed by locking the other person out, but what about if I'm not in the property? Like I voluntarily, not have the possession at the same time as Serenity.
Oh, you mean you're not there?
I'm just not there.
Well, that's fine. You don't actually have to literally be in possession at the same time, but you have to have legal access to it, right? The only problems arises if you show up and your good friend Serenity change the locks on you, right? Then there's a problem. You'll do a case like this next class, which I think explains it better, where there's two people in property as tenants in common, and one of them uses a factory or a warehouse, and they padlock the other one out, and that becomes problematic. Okay. So do we have any more questions on the 4 unities? Okay. So what I want to get about these unities is that all 4 must be present at all times. They must be present at the creation of the joint tenancy, and if at any point during the joint tenancy one of these unities is severed, then you go down the ladder to a tenancy in common. Okay. So, for example, sorry, I keep using them. Serenity and Jessica are joint tenants. Okay. If Serenity decided to sell me her interest, okay. Hold on. Cece, so what happens then if Serenity sells me her interest? They were joint tenants. Serenity sells me her interest. What happens then? Good. Okay. Very good. Walk through how each unity broken. Good. Right. Exactly. Perfect.
Well, they would have equal undivided shares.
Did Jessica and Serenity still have an equal share at that point?
No.
Serenity gave me hers, right?
Yeah.
So you got the interest. And now does Serenity have possession? She sold it to me, didn't she?
Oh, you're right. Okay.
So everyone see that, right? Once Serenity sells me her share of the joint tenancy, all 4 of the unities are severed. They're all gone. And that reduces it that now Jessica and I are tenants in common. And there's nothing wrong with tenants in common. There's absolutely nothing wrong with it. But the key difference is there's no survivorship right. So when I die, or poor Jessica, when I die, make it easier, right? Well, Jessica's a survivor, right? But she does not get my survivorship right. It goes to my heirs. Okay. Okay. So the most common way that the unities are severed is by transaction. But again, an easier way perhaps is by locking the person out. Yeah.
Does this work for stuff beyond land?
I'm sorry?
Can it work for stuff that isn't land related? Like can you do it for other property?
Like what?
Money.
You can set up a trust for amounts of money, but I mean, I guess you could do a joint ownership for a trust of money. I'm not exactly sure why you do that, but you could do that. I guess. Sure, why not? You can do whatever you want with money.
No, it just seems like you get creative and avoid
Oh, I see what you're saying. Right. So the reason why trusts exist is to avoid taxes.
Yep.
This is why most people who are sophisticated, I'm not one of them, instead of having, I don't have anything. I have a net negative wealth. If you find a random homeless guy in the street, he has a higher net worth than I do. True. It's true. He's closer to zero than I am. So student loans, they'll get you, man. So the short answer is yes. You can actually set up sophisticated trusts as a means to evade a lot of the tax transactions. That's why I don't have to worry about that. Not for a while, at least. Yes. So I think Norma asked before about adverse possession. So say you have two joint tenants, right? And one of them just never shows up. He's never to be found, right? And the other tenants, you know what? I'm going to be squatting in your claim. And for 10 years, right? Joint tenants living there. And he says, listen, I'm going to take your claim. After 10 years, and this is exactly actually what Norma was asking about, one joint tenant can actually assume the claim of the other joint tenant by adverse possession, and now it's owned fee simple. So you can actually squat against your loyal joint tenant if the joint tenant doesn't actually show up to enforce his claim. Everyone with me so far? Okay. Yeah, like I said, it's not a hard, but students always have a lot of questions, which I like. So far, I think you're doing pretty good. So I'll mention somewhat briefly, but not too briefly, the third co-tenancy we'll be talking about, which is a tenancy by the entirety. The easy way of thinking about this is it's like a joint tenancy with a fifth unity of marriage. The tenancy by the entirety is a special type of joint tenancy which is meant for married couples. So it simply adds the fifth unity of marriage. The biggest difference, though, is with a joint tenancy, Serenity can just sell me her stake, and that severs the unity. With a tenancy by the entirety, one spouse cannot sell it without the other's permission. Let me say that again. With a tenancy by the entirety, one spouse cannot sell without the other's permission. The only way with a tenancy by the entirety to sever the unities is to get a divorce or die. I mean, there's always death, right? Death and taxes, right? But the only way that the parties can willingly separate the estate is by getting divorced. There's a practical reason for this. Study this when we do family law in a week or so. But virtually every single aspect of property law concerning married couples was meant at avoiding debt collection. It was meant to avoid debt collection. Because if neither husband nor wife can actually sever the unity, okay? Imagine husband owns debt, right? The debtors can reach all the husband's property. But this Blackacre is not the husband's property, it's their joint property. So this was actually a ruse to evade creditors. The creditors could not reach Blackacre because it wasn't just husbands, the wife had an interest as well. And the wife had no debt, so they couldn't reach her. You'll find that most law affecting married couples was designed solely as a means to evade debt collection. It's almost comical when you start thinking about the history. Excuse me. The tenancy by the entirety only exists in half the states. It kind of exists in Texas. It's mentioned in some of the statutes, but for reasons we'll discuss next week with respect to community property law, it doesn't really matter. I'll explain why later. But it's not a it's not a particularly significant feature of property law in existence today. But it is on the books in Texas at least. So you should be familiar with it. All right. So any other questions on the tenancy by the entirety? No? All right. Let's do some questions. On page 346, there are a couple of good questions I want you guys to take a look at. All right, Kemi, you want to read number 1, please? Okay, so we have a situation here. O conveys Blackacre to A, B, and C as joint tenants. So Kemi, let's just start one step at a time. What are the interests of A, B, and C? There's going to be a really easy answer, but there'll be a hard follow-up. So what's the interest of A, B, and C, Kemi? Okay, how do you know that? Okay, that's wrong. But what do we have to establish to prove that people in fact are joint tenants? Yes, this is a not quite a trick, but the mere fact that something's labeled a joint tenant, unless the 4 unities are present, they're not joint tenants. Let me say that again. I can deceive you on an exam, right? I can say, oh yeah, it's A, B, and C as joint tenants, but they take it at different times, there's different instruments, whatever. So you need to walk through the 4 unities to determine if indeed they are joint tenants. Okay, so Kemi, walk me through the 4 unities, please, for A, B, and C. Good, so it's got the time. Good. Good. Same instrument. Good. Okay, what is their share? Yes, but how would you characterize their interests? They all have the same access to the land, right? They each have a claim, right? There are 3 separate claims to the land, but their claim is to the entirety of the property. Good. And Kemi, do they have full possession of the entire property? Yes, ma'am. Okay, very good. So it is indeed the case that A, B, and C are joint tenants, right? Raise your hand up.
Yeah, I wanted to ask you a question. Did you just go as far as say we have joint tenancy fee simple, or can you put that?
I would not say that because it's not really fee simple. And the reason why is that only one of them who wins the ultimate game of life will get it. Right? So it's not fee simple.
I know that they all have the property in its entirety, but so then would you say that they all have 100% of the property together, or that they each have?
I'm really going to resist you using numbers. And the reason why is someone will have the urge to say, well, they own 33%, they own 33%, they own 33%. So I like to just say that they have access to the entire property, and that's a better way of thinking about it conceptually. You can do that, but once you start putting numbers in, you may be led astray. Maybe not. I don't know. Maybe you can do it, but I don't like it. All right. All right. So Jimmy, let's read the next sentence. It says, A conveys his interest to D. What happens when A conveys his interest to D? Now be very careful. There's no more joint tenancy between whom?
D, so D doesn't get in on it, but B and C still.
Say that differently. You're correct, but I don't like getting in on it. It's a little.
So B and C are still joint tenants,
Yes.
but D is not a joint tenant with B.
Yes. Okay. I want everyone to think about this, right? So let me hold on. Let me switch windows. So you have A, B, and C. Right? We start out there as joint tenants. If you think about it, there are three separate relationships. There's AB, there's AC, there's BC. Right? They're all viewed as joint tenants. Okay. But then we have a transaction. A conveys his share to D. Okay. So what happens? Wherever we see A, we put D. So Jimmy, what's the relationship between D and B? Exactly. They're tenants in common. And why are they tenants in common?
Because multiple.
Once A made that transaction, he severed the unities, right? So now D steps into A's shoes. And any relationship that A previously had, D has. However, because unity severed, the relationship becomes a tenant in common.
Does that also change?
I'm not there yet. I'll get there in a second. So D and B are now tenants in common. What about Christian, D and C? How do we characterize that relationship? Yes. Right? The relationship between D and B, they're tenants in common. And relationship between D and C are tenants in common, right? But now we go down to Jesus, right? What about the relationship between B and C? How do we characterize that one? They're still joint tenants. That's right, Jesus. Why are they still joint tenants? Their relationship was saved, right? Nothing touched their relationship. So long as B and C still have their four unities together, they're still joint tenants. So what this teaches us, right, is we have a complicated situation. We have a piece of land with three co-tenants. I'm sorry, with three tenants on it. B and C together are joint tenants. D and B are tenants in common. And D and C are tenants in common. This is how you're going to have to start thinking. On the same piece of land, different tenants have different relationships to one another. Okay?
Okay, so I understand what you're putting up here, but what's the legal difference?
That's my next question. I'll get there in a second. Can I do it?
Sure.
Thank you. With your permission. So the next statement's this, right? Legal significance. B dies intestate. Okay, we'll go back up to George. In this situation right here, B dies without a will. So what happens?
Well, it says that he would leave it to H there.
Okay, well, he left. Yeah, so B as an heir. Okay. What happens to Blackacre? What happens to
Well, he can't. As far as between B and C, they would just go to survivor would just go to C.
Good. So what happens to B's interest upon his death? And then what does C get?
Fee simple. Or not fee simple, but
Well.
survivorship, he gets,
Okay.
he gets a thing in common with
Yes. Okay. So what happens, right? And this is where it gets a little bit tricky. And I'm going to break the rule I said before. Okay? If you think about it, I don't like doing it like this. But when B dies, okay, B had 1/3 and C had 1/3. Okay? Not exactly, but that's how I think about it. When B dies, C gets the right of survivorship. So C gets half. Okay? I'm sorry, I can't do math. 2/3. 2/3, yeah. I've had this really bad head cold for last week. I'm finally getting over it. I'm almost there, almost there. I couldn't even talk 2 days ago, so this is actually a significant improvement. C gets the right of survivorship. So now C has 2/3. What about D, Matthew? Yes, D has 1/3. And what's the relationship between D and C? Bingo. D and C are tenants in common. Right? This one was tricky. Okay? D and C are now tenants in common. However, and this only matters in the case of a sale, which is why I don't like using these numbers. But in the event of a sale, for example, C's share is 2/3 and D's share is 1/3. But even if that's the case, they both have access to the entire property that can't be locked out. Okay? Oh, I was going to call on you. No, sit down. Judge? All right, fine. Tell it to the judge. I actually once, I had a very sordid, a complicated clerkship interview process. And once I was actually interviewing with the judge, and I felt my phone vibrating. And I did what I'm not supposed to do. I kind of peeked at it. And it was another judge calling. It's like, oh, judge, can you use the bathroom, please? It's like, oh, yeah, go use my own bathroom. So I ran in. I took a call from one judge while I was interviewing with another one. So I have sympathy for James. So Kaylee and Anna, I'll get back to him in a second. Anna, what happens now if D dies? That's not in the question, but I'll add it. If D dies. In this situation. I'm sorry? D dies. Everyone has heirs. Yes, ma'am. Yeah, I saw people love saying if they have heirs. Everyone has heirs. I promise you, everyone has heirs. I'm not picking you, but for whatever reason, I just love thinking the idea of people dying without heirs. It's just lost student hang up on zombies. I don't know what it is, but it's like, oh, no heirs, right? Miss Haversham, right? Everyone has heirs. Very good. And it will go to D's heirs and so on and so on. Yeah.
So as far as they have access, whether you have 1/3 or 2/3, the only thing it comes down to is like 2/3 as far as like when you sell the property.
That's the only time it's going to matter. This is why I don't like using the numbers. But in the event that it ever came to a forced judicial sale, they'll chop it up, yeah.
So like if we see something on the test, we need to say 2/3 and 1/3.
I really wouldn't say it. I mean, I'm only giving this just because this example is really complicated if you understand it. But those numbers mean absolutely nothing unless there's a forced sale.
But as far as I'm not understanding why it matters that B and C are still doing tenants when it's going to come down to the both going to be tenants in common.
Well, the reason why it matters is because when B dies, C gets his interest. Otherwise, B's heir would have gotten it. That's why it matters. Right? If B and C were not joint tenants, then B's heir would have gotten the share. And then we'd have a new person in this situation. We'd have was H. I saw another hand somewhere. Yeah.
I guess I'm just confused at why, like we keep saying that it's only relevant when there's a forced sale, but you can exterminate it with a sale. So
I'm sorry, when I say for sale, if there's a conflict between the two tenants and they can't figure out how to live their lives, the court can step in and say, all right, you know what? I'm just going to sell the entire thing, and they're going to split the proceeds up. And they split it up based on what their share is. That's where it matters. Because all that A can sell is A's share, right? When A sells his share, he's letting someone else be a tenant. But that's not selling the entirety of Blackacre. Let's see, any other questions? Oh, I'm sorry, I didn't see you.
I guess I'm confused as to why, I guess the different relationships. If I thought that they had to be equal, and so when A severs the unity, I just don't understand why it went back, why B and C still kept their relationship.
Okay, so the reason why I wrote it out like this is, even though there are three, even though there are three tenants, there's three separate relationships, and this is how you have to view it. On a given piece of property, you can have 2 joint tenants and 1 co-tenant. You can have 6 co-tenants and 1 joint tenant. The original grantor can chop it up however he likes. So say there's a, make it easy. Let's say B and C are married, right? And he says, I want B and C to be joint tenants together, but I want you to be tenants in common with your cousin, right? Who's not as important to the family. You can check. Everything okay? Was the ticket cleared or? No, okay. All right. It's okay. You can chop it up however you want. Okay. And the reason why I write the relationship out, these 3 steps, is trying to visualize each one as a separate relationship. They don't all have to be on the same level. Okay. Let's move on to the case. Riddle against Harmon. All right, James, you want to? I had to graciously skip over you a moment ago. So you want to tell us the facts, please, in Riddle v. Harmon?
Yeah. So, Mr. and Mrs. Riddle, purchased the property, and I guess
Yes, his loving husband and wife, right?
right. And then, before Mrs. Riddle died, she went to her attorney and transferred the property to Harmon. I believe that's correct. And then, and then the husband gets quiet title of the property.
Mm-hmm.
And then the trial court refused to go through with the plan, and the property remained in joint tenancy. And the state of Mrs. Riddle appealed.
Good. So James, what was lovely wife, Miss Riddle, what was she trying to do here?
I guess she's just trying to transfer her share of the property to another party.
Why did she not want her husband to get it? It's not in the cafe facts, but why do you think she thought of her husband?
Probably didn't like her.
Yeah, this is a common theme, right? Where on a person's deathbed, they suddenly discover that upon their death, that their worthless husband, whoever it is, right, will be getting their share in the property. And you know, Miss Riddle thought, oh man, I want my kid to get it. I want this to get it. Right? You want someone else to get the property. So she calls her lawyer in, and she says, look, lawyer, I'm very close to death. In fact, she died, 20 days after executing this instrument. She said, look, I only have like 3 weeks to live. I want to write my husband out of this. How can I do it? Okay. So, Alyssa. So, if you were her lawyer and you were you were a smart California lawyer and you knew the law very well, what advice would you have given her had she had plenty of time to take care of this issue? What advice? What's a smart advice you would have given her? Good. And what would be the smart way of doing that, the smart way. This is the safe way. How? Yes. What do we call that transferring to a third party? I'm sorry? Good thought. Anyone know what I'm thinking of? What do you call when you transfer something to a straw man, right? You often hear this expression. The traditional way of dividing the unity is by using a straw man. Think of like a scarecrow, right? It doesn't really matter. You transfer the property temporarily to person X, that severs unity, then person X transfers it right back to you, and now instead of having a joint tenancy, you now have a tenancy in common, right? That would have been the safe way of doing it. But Jake, this isn't what happened. What advice did the lawyer give to Miss Riddle? Give it to herself. Why do you think the lawyer told Riddle to give it to herself? Right. So, I mean, there's probably a couple reasons why I did it. One, it's easier. It's cheaper, right? And also, it may have been clear that this woman was very short life, right? She may have been close to death. I mean, that seems to be clear from the facts. So he was like, I don't have time to go find a straw and do this entire elaborate transaction. So the lawyer took a shortcut. Now, as an aside, often law students don't think about legal malpractice, right? You haven't taken professional responsibility yet. You will take it soon. But in your days coming up as lawyers, and all of you will be lawyers, you're going to have to make a choice sometimes where you can either do the, complicated, expensive thing which guarantees your client's interests, or you can take a shortcut which maybe guarantees your client interests. Now, in this case, ultimately, the California court ruled that this shortcut was okay, right? But Tim, what do you think would have happened to this lawyer had the court came out the other way and said that this shortcut doesn't work? Well, what kind of ding are we talking about? Be very specific. Oh, it's worse than that. What happened to the client who, instead of getting the share in the property, gets nothing? What do you think that client's going to do? Sue for legal malpractice. Right. It's not just putting a ding on your record, right? It's not getting like a bad mark in your transcript. You get sued. And do you want to know what it's sued for? The value of Blackacre. Right? The heir was supposed to get whatever the amount of money was, whatever the value of this land was. The client didn't get what he probably should have gotten had the lawyer acted competently. Therefore, you get sued. So what makes this case interesting is when the lawyer gave this advice, a California court had held that this straw man was necessary, right? So this lawyer gave advice that was flatly inconsistent with the prevailing law at the time. Everyone get that, right? If any of you in the room do this, you will be on the hook for malpractice. This is not a joke. You can lose your license over this sort of thing. Okay? You can be suspended from the bar for this sort of thing. He did this, whatever, and it worked. Now, he got bailed out by the California courts. Now, I want to give you a rule of thumb. And this is a rule of thumb not just for this class, but for any of your classes. If your casebook ever includes a case from California, the California court is going to do one thing. It is going to reverse a common law rule. Let me say that again. Almost without fail, if your casebook deems a California case worthy of inclusion, it's because it reverses a common law rule. The reason why this lawyer didn't get nailed for malpractice is because the California court overruled its own precedent and got rid of a common law rule requiring a straw man. Okay? So for the first time, and certainly not the last time this semester, a lawyer who otherwise would have been liable to legal malpractice is saved by a California court overturning the common law. Okay? So what happened? Actually, I realized I skipped that row, so I'll come back. You're on the hook eventually, but Catherine, what did the court think about this requirement of using the straw man? What? Catherine, what was the history? Answering while she's on call. What was the history then of this straw man ritual? Where did this come from? Yeah, the twiggle. I remember that, right? So now we're talking about the lump of dirt because of that video. You remember, what we're talking about. So this entire idea, you can sign your paper now. You're off the hook. This entire idea now of requiring a third party to transfer derives from the notion of livericizing. The idea that you had to literally take a clump of dirt from one hand to another. And I think the opinion, which is being quite sarcastic, said it would be unseemly to transfer dirt from one hand to the other, right? You can't give yourself dirt. That doesn't work. So the court says that all these sorts of common law rules are so, excuse me, are so antiquated and so, barbaric, basically, that they are not consistent with our modern progressive society. And Catherine also raised another point that's very fair. You can create a joint tenancy without needing a third party. Believe it or not, at common law, in order to create a joint tenancy, it wasn't enough for it to say, Josh to Abe and Bill as joint tenants. You basically say Josh to Strawman, and then Strawman to these two as joint tenants. You'd have to do all these kind of disjointed transactions. So the legislature in California got rid of the need for a strawman for creating this joint tenancy. And what the court says here, is we should have the same rule for the destruction. So now in California, severing the unity is awfully simple. All you have to do is transfer it to yourself. Okay. Now, let's see, Ashley, what's the cost though of this rule? What's the downside? I mean, the rule makes some sense, right? It's a lot easier. But what's the cost of having this rule? What's the downside? And think of poor Mr. Riddle. Okay. When you're trying to sever the unities, the more people that are involved, the more public it becomes. And, oh, by the way, your husband may find out. Whereas if you can just do this to yourself, you can basically write your husband out without him knowing about it. So one of the reasons why the entire elaborate straw man ruse was helpful was it served as notice to other parties. It's like, oh, wow, you see that Josh just gave this to the straw man, whatever? Now, under the majority rule here, you can quietly cut your husband out of the picture without telling anybody.
I may have missed, but why was it not tenancy by entirety?
I don't think California has a tenancy by the entirety. I'm like 50% sure about that, but I don't think it has it. And even if you're married, right, you can still have a joint tenancy. You don't need to be tenancy by the entirety. Indeed, what happens if they got the property and then got married? Because they weren't married at the time, it wouldn't be a tenancy by the entirety.
Did you elect to not be by the entirety?
Sure. Yeah, you can elect whatever you want. You follow the intent of the grantor. If the grantor says joint tenancy, even if they're a married couple, it's a joint tenancy.
After the case in one of the notes, it talks about I think the wife's doing it handwritten and kind of tucking it away, but then the husband passes. Oh, you're coming to that.
Oh, no, no, I was like, yeah, she might be quiet about it, yeah.
But her just handwriting it and then never like letting anyone know, like even letting the county know or anybody, does it have any legal effect?
Oh, it does. I mean, we're not talking here about a will. Wills need to be governed by the statute of wills, but a transaction for severing unities satisfies the statute of frauds. I mean, if it's handwritten.
But then what if she wrote it, but then she didn't, like, could she say, oh, I didn't mean it? Like, that's why I didn't tell anybody?
It's a signed document. There's
Her own signature.
Yeah, it's her own signature. It's giving it to herself. I mean, all the parties are present, so to speak.
And then she doesn't have survivorship.
There's no more survivorship, no. All right. Questions? All right, so we have these three tenancies, the tenants in common, the joint tenancy, and the tenancy by the entirety. In terms of the joint tenancy, which is really the big one to think about, always ask yourself for the four unities present. It's not enough to simply see the question saying joint tenant, actually check for yourself. And once they're present, always be vigilant if any steps you're trying to take to defeat them by severing the unities. Any questions? I will see you all on Thursday. Thank you very much.